Stop scrolling. Put down whatever you're doing. Because something just happened at the highest court in the United States that's going to affect millions of retirees. And most of them have absolutely no idea it even occurred. A Supreme Court decision, not a split vote, not a narrow margin. 9-0. Every single justice, conservative and liberal, young and old, appointed by different presidents from different eras with completely different judicial philosophies. And they all agreed, unanimously. When that happens, it's not just a legal ruling, it's a message, a signal that something fundamental has shifted in American law. And when the shift involves retirement benefits, Social Security, pensions, and the financial security of millions of people who worked their entire lives expecting certain protections, you need to understand exactly what just changed. Because this decision doesn't just affect policy, it affects real people. Real families, real futures, and depending on your situation, it could either protect what you've earned or expose vulnerabilities you didn't even know existed. So let's break this down step by step. What the Supreme Court actually ruled, why it was unanimous, who it affects, and most importantly, what you need to do about it right now. What the case was about. This case wasn't flashy. It didn't make front-page headlines. It didn't involve a celebrity or a scandal. But it dealt with something that touches the lives of tens of millions of Americans, how federal agencies administer retirement benefits. Specifically, the case centered on whether certain government agencies, like those that manage Social Security, federal pensions, and related programs, have the legal authority to interpret and apply rules in ways that affect how benefits are calculated, distributed, and adjusted over time. For years, these agencies have been making administrative decisions. Decisions about cost of living adjustments, decisions about eligibility requirements, decisions about how work history is calculated, decisions about how benefits are reduced or delayed based on other income. And in many cases, these decisions were made without explicit authorization from Congress. The agencies claimed they had the authority to interpret the law and apply it as they saw fit. After all, they're the experts, right? They run the programs. They deal with the details every day. So it made sense, at least to them, that they should have some flexibility in how they apply the rules. But advocacy groups representing retirees disagreed. They argued that some of these administrative decisions went far beyond interpreting the law. They argued that agencies were essentially making new rules, rules that Congress never passed, and applying them in ways that reduced benefits, complicated claims, or denied eligibility to people who should have qualified. And now, the Supreme Court has agreed, unanimously. What the Supreme Court actually said. The ruling reinforces something called the major questions doctrine. Here's what that means in plain language. If a government agency wants to make a decision that has enormous economic or political significance, it can't just do it on its own authority. It needs clear, explicit permission from Congress. In other words, agencies can't just decide to reinterpret laws in ways that dramatically change how benefits work. If Congress didn't specifically authorize it, the agency doesn't have the power to do it. This might sound like a technical legal point, but it has massive real-world implications. Because over the years, federal agencies have made countless administrative decisions that affect how benefits are calculated. And many of those decisions were never explicitly authorized by Congress. They were based on the agency's interpretation of what the law meant, or what the agency thought was the most efficient way to administer the program, or what the agency believed was fair. But now, the Supreme Court has said that's not enough. If it's a major decision that affects millions of people and billions of dollars, Congress has to authorize it explicitly. Otherwise, it's not legally valid. Why this matters for retirees. Let's make this personal. If you're receiving Social Security right now, this ruling affects you. If you're about to retire and you've been given benefit estimates, this ruling affects you. If you've ever been told by a government agency that your benefits would be calculated a certain way, or that you didn't qualify for something you thought you should qualify for, this ruling affects you. Because some of those decisions that determined how much money you get every month, may have been based on administrative interpretations that are now legally questionable. Think about that. There are people right now who accepted a lower benefit amount because an agency told them that's what they qualified for. There are retirees who were told their cost of living adjustment would be calculated a certain way, and they accepted it because they had no reason to doubt the agency's authority. There are people who were denied certain benefits or had their claims delayed because of administrative rules that were never actually passed by Congress. And now, those rules are under legal scrutiny, which means there may be grounds to challenge them, to request recalculations, to appeal decisions that were based on interpretations that the Supreme Court has now said were not legally authorized. Who else this affects? Here's something most people aren't talking about. This ruling doesn't just affect U.S. citizens who've worked their whole lives in the country. It also affects millions of people who lived and worked in the United States on various immigration statuses and contributed to Social Security throughout their careers. Under current law, certain visa holders and former visa holders who paid into Social Security are entitled to benefits under specific conditions. There are bilateral agreements between the U.S. and other countries that determine how benefits are calculated for people who've worked in multiple countries. But in many cases, administrative interpretations have been used to restrict or complicate benefit claims for this population. People have been told they don't qualify or that their benefits will be reduced based on rules that were created administratively, not legislatively. And now, this Supreme Court decision potentially gives those individuals new legal ground to stand on. Because if the administrative rule wasn't explicitly authorized by Congress, it may not be legally valid. This is exactly the kind of intersection between immigration history, work history, and retirement law that rarely gets explained clearly. But it matters. It matters to millions of people, and it matters right now. What you should do with this information. Knowledge is only useful if you act on it, so here's exactly what you should do, step by step. Step 1. Request a full explanation of your benefits. If you're currently receiving Social Security or any federal retirement benefit, you have the right to request a detailed written explanation of how your benefit amount was calculated. Not a summary, not an estimate, a full breakdown. Request it. Get it in writing. Review it carefully. If anything seems unclear, inconsistent, or based on rules you don't understand, make note of it, because those might be the kinds of administrative interpretations that are now legally vulnerable. Step 2. Revisit your benefit estimates. If you're approaching retirement and you've received benefit estimates, those estimates may need to be reconsidered in light of this ruling. Estimates that were based on administrative interpretations that are now under judicial challenge may not reflect what you're actually entitled to. Contact the agency. Ask questions. Don't just accept the numbers you were given before. The legal ground has shifted. Step 3. Find out if legal organizations are taking action. Within weeks of a major Supreme Court ruling like this, legal advocacy organizations that specialize in elder law, retirement rights, and benefits administration will begin filing cases. They'll be looking for clients. They'll be organizing challenges. They'll be pushing for recalculations and appeals. Find out who's doing this work in your area or nationally. Reach out. Get on their radar. Being early matters. Step 4. Talk to your financial or legal advisor. If you have a financial planner, an attorney, or anyone advising you on retirement, contact them this week, not next month, this week. Ask them specifically how this ruling affects your retirement plan. If they're not aware of it, share this information with them. If they can't give you a clear answer, consider whether you need to find someone who can. Step 5. Stay informed. This ruling is just the beginning. There will be follow-up cases. There will be legislative responses, there will be agency guidance, there will be new interpretations and new challenges. You need to stay informed as this develops. Why a 9-0 decision matters so much. Let's zoom out for a moment. The Supreme Court is deeply divided on many issues: abortion, gun rights, voting laws, environmental regulation. On those issues, you see 5-4 decisions, 6-3 decisions, bitter dissents, sharp disagreements. But on this case, 9-0. That tells you something. It tells you that this wasn't a partisan issue. It wasn't about liberal versus conservative. It was about the rule of law. It was about whether unelected bureaucrats can make major decisions that affect millions of people without explicit authorization from the elected representatives in Congress. And every justice, regardless of ideology, said no, they can't. That's a powerful statement. It's a statement about accountability, about limits on government power, about protecting individuals from institutional overreach. And it's a statement that has real, tangible consequences for people who spent 30, 40, 50 years working, paying taxes, contributing to a system with the promise that it would be there for them when they retired. Those people deserve to have that promise honored, not reinterpreted, not redefined by agency officials, honored as it was made. And this ruling is a step toward that. What happens next? This decision will ripple through the system for years. Congress will now face pressure to either explicitly authorize the administrative practices that have been called into question or to admit that those practices were never legally sound. Either way, there will be battles. Legislative battles, legal battles, administrative battles, and in the middle of all that, there will be real people trying to get the benefits they're entitled to. That's where clarity matters. That's where understanding your rights matters. That's where acting quickly and strategically matters. Because while the courts and Congress fight over policy, your retirement doesn't wait. Your bills don't wait. Your financial security doesn't wait. So you need to be proactive. You need to be informed, and you need to be ready to act when opportunities arise. Final thoughts. This ruling is historic, it's unanimous, and it's going to reshape how retirement benefits are administered in the United States for years to come. But whether it helps you or not depends entirely on whether you understand what just happened and what you do about it. So don't ignore this. Don't assume someone else will handle it. Don't wait for a letter in the mail that may never come. Take action. Request your benefit breakdown. Revisit your estimates. Find legal advocates. Talk to your advisors. Stay informed, because this is your retirement, your future, your security, and no one is going to fight for it harder than you. So fight smart, fight informed, and don't let this moment pass you by.